very strong arguments coming from Kapil Sibal, because he says that for 200 years it is status quo. Heavens are not going to fall if status quo is granted, and there is a suo motu FIR. I'm really disturbed by this, what's happening in our country. Your lordships must put a stop to this. And what is the urgency to this? The High Court the very next day, and what is the urgency for the High Court to say that ceremonies can be performed, to which Tussle has also submitted. The Waqf Act has overriding power over other laws, so no order can be passed. The law includes order. Very important arguments coming in there. Rajesh Kalapa.
So of course the Waqf board is making a very strong pitch for the fact that there should be continuance of status quo, and also the fact that there should not be any religious activity other than that which has been practiced so far, as claimed by them for the last 200 years. And if that were the case, then certainly tomorrow Ganesh Chaturthi, which is a very important festival in Karnataka and in Maharashtra, will perhaps not be held if that were the argument were taken into account. But the very fact that the timing of the High Court and the fact that the matter has reached the Supreme Court, and this kind of a racy kind of commentary which we are now hearing, I think is really a run-up to Ganesh Chaturthi tomorrow. Whether Ganesh Chaturthi will actually be held in the Idgah Maidan or not. And that of course is left to the Supreme Court of India. And if the court were to finally decide that if the Idgah Maidan were to be used by other communities to foster fraternity and other, so the ideals of the Constitution, then perhaps they will allow for the Maidan to be used by other communities as well. But and if this were the case, then I think this kind of a ruling will kind of have cumulative effect on every Idgah Maidan across the country. And so from that point of view, I think this is a very important legal development which is taking place in the Supreme Court today. And one has to watch it very, with great interest to see that to see how the court is thinking and how ideas have evolved over a period in time, whether politics has trumped everything else, whether the issues other than politics have come. I think it's the very fact that this important argument is taking place today at this time, I think is extremely it's a commentary on how things are today.
In fact, stay with us. Let me once again go back to Mr. Swapnil Kothari for more on this. Mr. Kothari, how much of this actually boils down to who owns the land? And the Waqf board, of course, has been saying that since there is this 1964 precedent on the part of the Supreme Court that ruled in the Waqf's favor, that the land belongs to them and that there's absolutely no judicial endorsement yet of the state's claim to that piece of land, and therefore what was in fact held in 1964 should still apply in the Supreme Court's deliberations. How much weight do you think that specific argument carries?
Well, that argument about ownership, yes, that may carry a little bit of a weight, but I think to quote a 64 judgment in 2022 and say that nothing has transpired in between, nothing has changed, the climes haven't changed, the times haven't changed, people haven't evolved, is to be frozen in time. Now, we lawyers have this very bad habit of using precedents, even if it's a very weak one, and if it goes in our favor, and we all do that all the time. So I will not blame any advocate who holds the brief for any of the parties either way. But the point is that when you look at it comprehensively and holistically, if it's the secular democracy that we are looking for, if it's Article 25 subject to reasonable restrictions, one of which is public order, and overall perspective on which Maidan should be used for what over a period of time, then I think the Supreme Court will, after this order, pave the way for a lot many other Maidans or a lot many other grounds, which can be used for religious purposes either ways. Even if it's a Hindu ground, it can be used for Muslim purposes or Parsi purposes, or even if it's a Parsi ground or something of that nature, which can be used for other religious. So what the Supreme Court will try to do then, in this, after it passes a judgment, it should be prepared mentally for more petitions, for more such applications from more diverse religious factions, and it should be prepared for more investment of more judicial time and resources.
Right.
Because ultimately this is something which should have been resolved by two factions across the table and should not have reached the court, because then the court will have to look at it from the legal perspective, which is a title perspective, which Absolutely. Is the Waqf law, which is the Waqf property, which is the constitution of the Waqf. So all of these arguments then tend to be extremely legal. which then eventually open up a Pandora's box across the country, especially in a democracy which is so much governed by not only politics, but religion and politics make a very, very potent venom.
Right.
Let me tell you that. And that is extremely harmful and poisonous for the entire democracy as a whole. So the Supreme Court will have to do its job, whatever it is. It has to do it. But then, we are, really opening up a Pandora's box for more, or should I say, in legal terms, floodgates for more litigation.
Absolutely. In fact, let me once again go across to Nilashish, who's monitoring all the updates from the Supreme Court. Nilashish, there have been some more developments by way of observations as well as questions asked to each of the protesting parties there. And there's been an exchange between Justice Oka as well as Mr. Mukul Rohatgi. So if you could just take our viewers through that as well.
Well, yes, Siddharth, Senior Advocate Mukul Rohatgi now is appearing for the state of Karnataka, and Justice Oka has asked him whether at any point in time before, any year before, has the state or the BBMP allowed festivities to be to take place on that land. Mukul Rohatgi has said no. However, very interestingly, what Mukul Rohatgi on behalf of the state says is that even if it was not used in the past, it cannot be an argument to say that it cannot be used right now. Of course, he was answering a question by the bench wherein it was said that if you see the order of the single judge, even the single judge has granted liberty to apply for modification. Instead of doing that, you came in for appeal. But as far as Mukul Rohatgi is concerned, for the state of Karnataka, they are saying that that argument that at any time prior this land was not used for any religious festivities does not exclude them from doing it now. It is not an argument that can be raised, is what the state says. The interim order was passed by a single judge, was based on the Revenue Authority, says Mukul Rohatgi, and he also says that 15 years ago, when similar issues arose, an informal committee was formed, including the Minister of Waqf, and members agreed to allow use of ground for Dussehra and other festivals, including Shivratri, and this decision was taken 15 years ago. Dushyant Dave, of course, appearing for the Idgah, also said that as far as the judge's order is concerned, there was a decree that was passed which permanently restrained the corporation from entering the property, and that was confirmed by the court. And what is surprising is that the corporation thereafter, which has been permanently injuncted, asks us, as in the Waqf, to show title to the particular property. Now, Dushyant Dave goes on to say, then after the single judge had protected us, the government filed an appeal and questions how the government can actually come into this particular issue, because it was to do with the corporation and the Waqf. Now, Dushyant Dave talks about religious freedom under the constitution to say that it is necessary to not give an impression to religious minorities that their rights can be trampled upon like this. Of course, arguments now being submitted by Senior Advocate Mukul Rohatgi on part of the wherein he is saying that even if there were no celebrations or festivities allowed on that land before, that they hadn't taken place before, that does not mean that it cannot in the future or now. Also, Siddharth, Justice Oka asking about whether this decision was only by political parties. Mukul Rohatgi says one of the petitioners before this court was a part of the meeting. For the past 200 years, says Rohatgi, the land was used as a playground for children, and all revenue entries are in the name of the state, again laying claim to the land, the state of Karnataka.
Absolutely, but just one point of clarification there, Nilashish. So is there a clear contradiction between what Mr. Sibal, who's representing the Waqf in this particular case, is arguing versus what Mr. Rohatgi has said? Because Mr. Sibal has said that in the past, the land has not been used for any other religious festivals with the exception of Ramzan as well as Bakrid. But Mr. Rohatgi is pointing out towards a certain precedent that was adopted 15 years ago when an informal committee was formed wherein a decision was taken to also allow Hindu festivities to proceed at the concerned venue. So clearly a factual disagreement there between Mr. Sibal and Mr. Rohatgi.
Well, yes, absolutely, Siddharth. Mr. Rohatgi, of course, saying that there was an informal committee that was constituted, and there were a number of people who were a part of it, including one of the petitioners before this particular court, of course referring to the Waqf board in Karnataka. But the question that arises is with regard to this specific property, and that is why Justice Oka is saying that the decision of this informal committee was only by political parties. So to distinguish between the current situation and what happened 15 years ago is what the court is trying to figure out, whether this applies to this particular situation. Absolutely. As far as land rights are concerned, when the Waqf board says that it is a Waqf land.
Right. So Justice Oka saying, see, for 200 years this land was not used for this celebration, and Justice Oka asks, was it at any point in time used for any other purpose? Dushyant Dave then says this is nothing but unlawful encroachment, rights of minorities are being trampled upon, and Mr. Rohatgi, then representing the state of Karnataka, actually gets into some of the specifics. He says the Revenue Authority order was the basis of the single judge order. He says 15 years ago, when such a dispute arose, all parties, Deputy Commissioner and Minister was also present. They agreed to allow the land to be used for Dussehra and Ganesh Chaturthi. For the last 200 years, this land is being used as a playground for children, and all revenue entries are in the name of the state. So, Mr. Kalapa, coming to you, two contentions being put forth by Mr. Rohatgi. One is that this land belongs to the state, and secondly, contradicting Kapil Sibal, he says that 15 years ago there was another precedent that was set, wherein an informal committee was formed which agreed to also allow the celebration of Hindu religious festivals such as Dussehra as well as Ganesh Chaturthi. So does this therefore tilt the argument in favor of the state, which has been empowered by the Karnataka High Court in its previous order to allow cultural festivities of that nature to go ahead on the 31st?
No, Siddharth, I don't know. I think essentially it's a question of whom does the land first belong to. And if the court comes to a conclusion that the land belongs to either the Waqf board or to the state, only then can they proceed on a different basis. Now, if the Waqf board has made a claim and stated that this is Waqf land, and if there is no challenge to that, then it finally becomes final unless there is some challenge to it, and that challenge ought to have been in a civil court, right? Or it ought to have been in the jurisdictional court. Now, I don't know if the state has challenged that. I think essentially everything will begin from the fact that this the ownership of the land is finally in question, and until that ownership is decided one way or another, I don't think these issues can be at large, but of course it is for the Supreme Court to finally decide. Right. Now, if there are certain concessions made by the landowner and said that this kind of activity can be permitted and this kind of activity can be permitted, now it is, unless the ownership is established, it's difficult for the court to say, okay, we are now doing away with this kind of ownership and we are saying that this kind of activity can be permitted. In my view, I think it's difficult for the court to take such a view unless the title is finally first established. And that, I think, is the most important thing in this matter. And I honestly don't know. I have not seen the judgment of the High Court. I don't know if that fact has been taken into consideration by the High Court. In fact, the judgment of the High Court, the order of the High Court that was delivered on the 26th of August said that the ownership appears to be in dispute. Now, taking this to Mr. Kothari, is the Supreme Court here in a bit of a difficult position because this bench was constituted in a matter of about 15 to 20 minutes. And if the basis for any order that it gives out is to first establish the ownership of the land, does it really have the time at its disposal to do that within a short span of time, given that the 31st is in fact upon us? It's just a matter of a few hours now, and therefore a decision needs to be taken as to whether or not this Ganesh Chaturthi celebration can in fact be allowed to go ahead. So if at all there is an interim order that is issued by the court, what can it actually do given the limited time it has to decide the issue?
Well, I don't think that the interim order can be that Ganesh Chaturthi celebration should be allowed. If it has to be as forming part of a final order. Now, the Supreme Court is well equipped, and more often than not in its past history of 72 years now, I think it has given many such judgments, and it has done so within a very short period of time. And it has to do so even today on the basis of the evidence that has been proffered before it. So if the evidence is there, then obviously, it has to go by that. It has to weigh the evidence. And even if it's just upon the ownership of the land, I don't think it will rest only upon the ownership of the land.
Okay.
It will have to look at a lot of other considerations as well, whether to, first of all, the Article 25,
Yes.
which is a fundamental right. Secondly, subject to reasonable restrictions, which is public order, law and morality.
Yes.
Whether there are going to be riots taking place, whether the third thing is that public disorder will be there in terms of many litigations before the Supreme Court, which again will result in too much of judicial resources and judicial time. So it cannot just depend upon one particular aspect. It has to look at 3-4 other things, and then eventually it has to come to a conclusion that as to what sort of decision it has to take and whether or not it is going to have more legal ramifications. And rather than, state ramifications in terms of law and order, it has to look at more legal ramifications. The state ramifications is a burden of the state, because law and order is a state subject to contain riots and to have this kind of posse of police forces which is there, and CRPF forces, whatever are there, surrounding the precincts of this particular Maidan. It's very clear that the state is well prepared for any untoward incident. But that should not stop the court from taking a decision one way or the other. But in my opinion, this is a decision which is going to be a landmark decision.
Okay.
Whether it comes today, whether it, hopefully I'm sure it will come today itself, so as to, put a quietus on this matter. And it will really pave the way for future generations to come in terms of whether or not eventually both the factions or religious disparity will eventually have to give way to secularism, and to say that, look, there has to be fraternal brotherhood, and it's no point going to courts one way or the other, because this is all going to result into further and further separatism, which the politicians are very well used to exploiting. And this itself is a political upheaval as well. In my opinion, this is more politics. This row has been raised because of politics more than anything else. Nobody is really interested in the legalese of ownership, title, who can get to play, whether children can play cricket, whether Independence Day, Republic Day, whether there has to be Ganesh Chaturthi, whether there will be Dussehra,
Sure.
all of those things. And especially that argument which was there 15 years ago, that the joint meeting came
Yes.
to a conclusion
Yes.
that religious activities should be allowed of all nature. Then I think that sort of a compromise, or sort of an arrangement, a mutual arrangement, will definitely have a tremendous amount of weightage in the decision of the Supreme Court.
Absolutely. It's interesting that you say that, Mr. Kothari, because Mr. Rohatgi emphasized the use of the word informal. So it was a compromise, like you said, wherein a decision was taken to also allow Rajyotsava celebrations as well as Ganesh Chaturthi and Dussehra, among other Hindu festivals. Let me also take this across to Mr. S.S. Ram, who's joining us on the broadcast for his inputs. Mr. Ram, what do you think would be the implications of a judgment that is not categorical in nature and leaves a fair amount of the matter in limbo, given the limited time at hand before the Ganesh Chaturthi celebrations commence tomorrow?
Good evening. First of all, it's quite surprising that successive governments all these years haven't bothered to look into this matter seriously, considering the sensitivity of nature of such properties in a prime area which is being used by one particular religion. That's quite surprising. And we can't go by assumptions, we can't go by precedents, we can't go by it was considered to be X, Y, Z. I'm sure there should be a proper ownership to the title, be it X, Y, Z or the state, and if so, it has to be for everyone to use it for the purpose that is possible for them, more in a harmonious way. I'm sure the Supreme Court, at least now, let it put an order which gives a proper solution to this problem. For the years to come, rather than allowing it to be in limbo even at this point in time. So that would be my expectation, please.
Absolutely. Let me go across to Nilashish once again. Nilashish, more correspondence between Justice Oka as well as Mr. Rohatgi. More questions being asked by the judge to Mr. Rohatgi, who's representing the state. Mr. Rohatgi has been saying that this land does not belong to the Waqf nor the BBMP. It belongs to the state government. If you could just give our viewers a perspective of that exchange between the judge and Mr. Rohatgi.
Absolutely, Siddharth. Just to put this in perspective, initially, let's not forget, Mukul Rohatgi had said that an informal committee, which basically is a quasi-judicial body, had a meeting on similar issues, and they had agreed to allow the use of the land for Dussehra and other religious festivals. Now, Mukul Rohatgi goes on to say that in this situation, when the Joint Commissioner makes a finding that it belongs to the government, unless this order is set aside, the finding of the quasi-judicial body will stand. And that is something that he goes on to equate as far as the High Court order is concerned, where he says, why did the single judge thereafter only grant 2 days use? He says that the single judge allowed state to celebrate Independence Day and Republic Day. Why is this allowed? If I'm the owner, I would not allow it. This is not consistent with exclusive ownership or title. Now, Justice Oka is questioning Mukul Rohatgi as far as injunction, the decree of injunction is concerned. And he says, isn't there a decree of injunction in operation? Mukul Rohatgi says that the injunction is against them not to build a school. However, Justice Oka goes on to show that it says that the BBMP is permanently injuncted and they cannot enter the property and build. If they can't even enter the land, how can they allow the celebration of a festival? What Mukul Rohatgi is saying beyond this is that it is the state that is before the court right now. They are not saying that it is the corporation. So the injunction on the corporation is irrelevant in a way, is what Mukul Rohatgi is saying at this point. So in response to the injunction question, Mukul Rohatgi says that here it's the state and not the corporation. But Justice Oka is asking that when there is an injunction against the corporation from entering, can they be allowed to organize a function or a festival of this nature? Of course, the matter continues with Mukul Rohatgi arguing that at the end of the day, if you look at the Supreme Court judgment from 1964, it is unclear as to who the owner is. So if nobody is the owner, the state is the owner is the argument. Mukul Rohatgi goes on to say that evidence on behalf of the corporation shows that there are footpaths across the land. Supreme Court says children play in the ground, which won't create title for BBMP. That is fair enough, but it can't create a title in the favor of Waqf either. So the argument again revolves around the fact that when there is no owner, the state is the owner. The 1964 judgment, Mukul Rohatgi says, is not clear about title. It says that it cannot be, the Supreme Court judgment says that it cannot be said that the land belongs to the corporation. Mukul Rohatgi says so be it, but it does not say it belongs to the Waqf either. So when there is no ownership of the land, it belongs to the state. An injunction is against BBMP. Here the state is saying that we own the land and therefore we can pass orders, appropriate orders, with regard to the celebration of Ganesh Utsav tomorrow.
Right, Mr. Kalapa, let me in fact throw that at you, because in 1964, according to the Waqf, and the Waqf believes that the judgment was categorical enough in allotting that piece of land or acknowledging the fact that the land is owned by the Waqf board. Now, Mr. Rohatgi, representing the state of Karnataka, says that the judgment was ambiguous. So clearly, there is a difference here in the interpretation of the 1964 judgment by the Waqf board as well as the state of Karnataka. That's point number one. But does the Revenues Department's decision of the state government to arrogate itself the ownership to the title of the land, does that carry more weightage in the deliberations of the court than the precedent that was set way back in 1964 when the Waqf believes the court ruled in its favor?
If the Supreme Court has passed an order in 1964, and from my reading of Article 142 of the Constitution, that a judgment of the Supreme Court is a law of the land, then that judgment cannot be varied by anybody other than the Supreme Court itself. Now, if the Supreme Court has passed an order in 1964, that order holds good for all times to come unless the court itself were to vary its order. And now if the time has come and the court believes that it can actually vary its order, then it's most welcome to change its order. But insofar as the 1964 decision is concerned, as on today, without varying the order, that is the law of the land. Now, if insofar as the fact that the court has held a particular way in 1964, that automatically cannot, change over with the passage of time. That has to be changed only by the will of the Supreme Court, and the court alone has that power. Now, if the arguments of either party are accepted by the court, then certainly it can vary that order of 1964. But I think enough grounds or reasons have to be mentioned by the court itself as to why the 1964 order is not good, or so on and so forth. But I'm very, it's a very curious kind of development that Justice Oka is taking a lot of interest in this, because he doesn't happen to be from Karnataka, but he was the Chief Justice of Karnataka, and perhaps he has had occasion to deal with issues similar to this or this itself. And perhaps that's the reason he's asking a lot of questions. And this was a matter of curiosity.
Absolutely. And Mr. Kothari, this does boil down to what exactly can be defined as status quo at the present moment. Now, the Waqf board believes that status quo is that the land belongs to the Waqf. Mr. Rohatgi says that since the Revenue Department issued a circular notifying the land as government land, the status quo has changed. And therefore, the current status quo, as per Mr. Rohatgi, is that the state is the owner. And that's precisely why Justice Oka is asking so many questions of the representative of the state in the court, which is Mr. Rohatgi, about why he is justifying this piece of land as belonging to the state government.
Well, yes, Mr. Oka used to be the Chief Justice of the Karnataka High Court, and that's the reason why Chief Justice U.U. Lalit must have taken him as one of the, judges today to decide this particular matter. So I'm not surprised that Mr. Oka is taking a keen interest, because I'm sure he's well aware of all the happenings that take place in Karnataka, or did take place when he was the Chief Justice at that time. Now, to ask these questions of Mr. Rohatgi is obviously giving me an indication over a period of time that I've been hearing, about this matter, and the way the course of the arguments that have taken place in the past 1 hour is that the Supreme Court is more inclined to make this as an open land without boundaries, so as to allow religious activities of any nature. So I see it going that way from what I'm looking at the questions, because the court doesn't seem to be hinged by the fact that this is a Waqf land, in as much as it is hinged by the fact that there was some sort of a, oral sort of a compromise that took place, and that when there is no particular ownership specified, then obviously it is the state that owns it, and once the state owns it, then it becomes an open land without boundaries, and the state has the full power within itself as the executive to take place, to allow any activities of any nature that it deems fit, subject to law and order and public order and morality.
Right.
So
Nilesh, coming back to you once again. In fact, Mr. Rohatgi has made more submissions now before the court, where Kapil Sibal had earlier said that this land also has a part of it that's actually a kabristan or a burial ground. And Mr. Rohatgi has said that exclusive possession means nobody can walk through this. This is different. He's also said that nobody can be an exclusive owner of a burial ground in this country. What exactly is he trying to say when he's rebutting Mr. Kapil Sibal there?
Well, absolutely, Siddharth, Mukul Rohatgi talking about exclusive possession and, in fact, countering the claims of the Waqf board, saying that exclusive possession means that nobody can walk through, that there can't be, that no one can be an owner of a burial ground in this country. The basic point that he's making at the end of the day is what is the current position of that particular ground. He says it is an open ground. They are allowed 2 days prayer in that ground. There is a municipal tank. There are footpaths. Children are playing around the year. How is this exclusive possession? Now, when it comes to exclusive possession, he says that it means that nobody can walk through. This, of course, is different, is what he says. He goes on to state that there was an argument with regard to the Waqf Act, also Waqf Act of 1995, and he says that has no application in this case. It is a previous act that is in play as far as this particular case is concerned. But his basic argument is, when there is a footpath, when there's a municipal tank, when there's a playground, there's a burial ground by their own admission, and no one doubts that, no one disputes that. In that situation, how can you say you have exclusive possession? Because that is not the clear definition of exclusive possession. That is the essential argument that is being made to counter the claims of the Waqf board by Mukul Rohatgi on part of the state of Karnataka. Siddharth.
Right, and Mr. Shriram, coming to you, what do you believe now is the scope for any kind of a compromise in the build-up to tomorrow? Because informal committees have been set up in the past. That's something that Mr. Rohatgi pointed out towards. But do you see any scope for a compromise given the extremely rigid positions that both parties have taken in this particular matter?
Oh, given the impression that always the other religions are more secular than the Hindus, I think they must show some magnanimity now and ensure that the Ganesh festival happens tomorrow, and then come to a final firm conclusion as to who it belongs to, and thereafter one can look into what is going to happen. Because we always talk about secularism, we always talk about brotherhood. Why can't a Ganesh festival happen there? Even presuming for a fact, for a minute, that let's assume that it probably belongs to one particular section. After all, it's an open ground and it's for the interest of a larger community. Why can't they be allowed to celebrate? And let's put this question to a firm finale, maybe in the days to come ahead. That would be my view, please.
Right. In fact, more interesting submissions, Mr. Sriram, and it's taking off from what you just said. In fact, Mr. Rohatgi is also echoing you in a way in the court. And Mr. Rohatgi says, what has the High Court done? Every part of this country, you have festivals, he says. In Bengal, you have the Durga Puja. In Maharashtra, roads are closed. One should be broad-minded. What is going to happen if Ganesh Chaturthi is allowed for 2 days? That's the argument that you also made. Nilashish, in fact, coming back to you, more exchanges now between Mr. Rohatgi and now Mr. Dushyant Dave also presenting his arguments. Mr. Rohatgi says, can someone say no because it's a Hindu festival? And Mr. Dave responds by saying, I wonder if any temple in this country, minority community will be allowed for prayers. So this is now going into the domain, Nilashish, of who owns that property, and however broad-minded one person might be, whether or not, if it's a certain religious place of worship, can the culture and the heritage and the practices of another religion be practiced within those premises? That's the dispute now between Mr. Rohatgi and Mr. Dave.
Well, absolutely heated discussions and arguments taking place in the Supreme Court at this point. Mukul Rohatgi says that one must be broad-minded and says what really will go wrong if you allow celebration of Ganesh Chaturthi at that ground for a day or two. Now, he also says that can someone say no if it's a Hindu festival, given the fact that it is government land? Now, he's going on the pretext that he has proven and established that the land belongs to the state. Now, Dushyant Dave says the question I ask is whether in a temple a Muslim person will be allowed to go in for prayer. So, of course, a clear deviation from the legal arguments here, getting heated in Supreme Court. The court also asking the councils to cool down a little bit. The court has been discussing amongst themselves as of now, but Mukul Rohatgi says that the 2-acre land is not a mosque. That is the difference between a temple and this particular ground. Kapil Sibal also says we all know it is an Idgah and it is not a mosque, but the point is it is an Idgah and we claim ownership of that land. So, of course, at this point in time, the judges are discussing amongst themselves. It did get a little heated in court, and the judges have asked the councils to calm down, given the time at this point. Solicitor General Tushar Mehta has also intervened at this point, saying that the entire premise of this submission is that what is the value of the register and what is the value of the entry. He's again talking about being allowed, the order that passed the land as Waqf land. So he's talking about the entire premise being based on that. Of course, the questions that were being addressed by the two councils for both sides, Mukul Rohatgi and Dushyant Dave and Kapil Sibal on the other side, was about the ownership. But Mukul Rohatgi
right,
did say that
the judges are also having a discussion among themselves. We'll of course wait and see how long these deliberations continue. We request our guests to stay with us, and we'll come back with more updates on the other side of this very short break. Stay tuned.